My sister's lawyer looked me in the eye and said, "We're offering $80,000 for everything, for 6 years of my life, for $847,000 of my own money, for the algorithm that was about to close a $95 million deal." He slid a pen across the table. I thought about my father, who died 14 months ago, and the sealed letter in my jacket that said, "Not yet." I thought about the morning I had pressed one button and watched 7 financial firms go dark. I thought about the forged signature sitting in a court file with my name on it. Then I looked at my sister, and I said nothing, because I didn't need to. The judge already had the document, and the document said everything. Cook County Family Court, Courtroom 4C, 9:02 a.m. I had been sitting in that room for 11 minutes before anything was said that mattered. The room smelled of cleaning solution and old wood. The overhead lights buzzed at a frequency you stop noticing after the first hour. The gallery behind me held 12 people I didn't recognize, and 2 I did. Federal observers, sitting quietly in the back row, neither of them looking at anything in particular. I had worn my father's watch. It wasn't a statement. It was a compass. Diana sat at the opposing table, in a charcoal blazer, her posture composed, her hands folded. She had not looked at me since she walked in. That was fine. I understood the strategy. When you are about to claim something that isn't yours, you learn not to make eye contact with the person you are taking it from. Her attorney, Jeffrey Hartley, $400 an hour, navy suit, wireless earpiece, stood and began to outline Diana's position in measured, confident language. He spoke for 6 minutes. He said, "Vertex Tech co-developed Axiom." He said, "Ethan Brooks received fair compensation during the development period." He said, "The settlement offer of $80,000 fairly recognizes his early contributions." Early contributions. I wrote those 2 words on my legal pad. I underlined them once. Then I set my pen down. Hartley slid the settlement document across the table toward my attorney, Robert Coleman. Coleman didn't touch it. He looked at it the way a structural engineer looks at a cracked foundation. Not with alarm, but with the quiet certainty that he already knew what was wrong. Hartley pushed the pen toward me next. I want to be precise about what I felt in that moment. Not rage. Not fear. Not the particular grief of watching someone rewrite the past with a straight face. I felt clarity. The kind of clarity that comes after you've spent 6 years building something that works exactly the way you designed it to. And you know, down to the molecular level, every choice that went into it. I did not reach for the pen. My name is Ethan Brooks. 6 years ago, I was a senior software engineer with 4 notebooks, a 1-bedroom apartment in Lincoln Square, and a problem I couldn't stop thinking about. The financial industry's risk modeling systems were 17 years behind what the underlying mathematics could support. Real-time multi-asset risk calculation took between 4 and 11 seconds. In 2008, that cost the industry $2.3 trillion in preventable losses. I believed I could reduce that latency to under 1 second. I quit my job in March. I gave myself 2 years and every dollar I had saved. What I built was Axiom, a compression algorithm that reduced multi-asset risk model latency from an industry average of 4 to 11 seconds to 312 milliseconds. Independently validated by 2 quantitative analysts who had no financial stake in the result. I funded the entire development personally. $847,247.38 over 24 months. Vertex Tech, the company Diana ran, contributed $0 to Axiom's development. Not a partial contribution. Not a reduced contribution. 0. I nodded to Coleman. He stood, opened his folder, and submitted a single document to the court. The document was a licensing agreement. Specifically, the operating license for Axiom's core algorithm, issued 4 years earlier to my personal LLC, Ethan Raymond Brooks Ventures, LLC. as the sole licensor of record. The license predated Vertex Tech's existence by 8 months. Judge Morris took the document. He read it for approximately 30 seconds. He took off his glasses. He set them on the bench. Then he looked at me directly and asked, "Mr. Brooks, do you mean to tell me that without your personal authorization, this company cannot legally operate its core product?" I said, "Yes, Your Honor. That is exactly what I mean." The room adjusted. I don't have a better phrase for it. Something shifted in the molecular weight of the air. Hartley's pen stopped moving. Diana looked at the document. Her hands, still folded, tightened once. My father used to say, "The invisible structure holds everything. Build the invisible parts strongest, and let the load reveal itself." In that moment, the load was revealing itself, and the room was beginning to understand what had been holding everything up all along. Let me go back to the beginning, because the beginning matters. Not the legal beginning, not the incorporation papers or the licensing agreements, or the LLC filings that Mr. Coleman would eventually use to dismantle Diana's entire case. I mean the real beginning. The human one. The one that started in a kitchen in Evanston on a Sunday afternoon when Diana was 22 years old and I was 27, and our father had just told us that the engineering firm he had worked at for 19 years was shutting down its Chicago division. Diana cried. She was always the one who cried first in our family. Not because she was weak, I want to be clear about that, but because she felt things faster than the rest of us. She processed emotion at a speed that the rest of the Brooks family had never quite learned. I did not cry. I sat at the kitchen table and I calculated. My father had $214,000 in savings. A paid-off house in Evanston worth roughly $340,000 at the time. A pension that would cover basic expenses but nothing more. He was 58 years old, and the industry he had given his life to had just informed him, in the language of corporate restructuring, that his 3 decades of expertise were no longer required. I was working as a senior software engineer at a financial technology firm downtown. I had been there 4 years. I was good at my job in the way that people are good at jobs that are too small for them. Efficiently, quietly, and with a growing awareness that I was solving other people's problems when I should have been solving my own. That Sunday, driving home from Evanston, I made a decision. I would build something, not for the money, though the money would matter eventually. I would build something because I had watched my father spend 31 years constructing frameworks that held other people's buildings up. And I had decided, somewhere on the I-94 heading back into the city, that I was not going to make the same trade. I spent the first 8 months designing the architecture in my head. I filled 4 notebooks with equations, diagrams, logic maps. I quit my job in March of that year, a decision that my mother called reckless and my father called brave, and Diana called, characteristically, both at the same time. I gave myself 2 years and everything I had saved. In month 11, Diana called me. She had been accepted to the Booth School of Business at the University of Chicago. Full program. She had the grades, she had the aptitude, but the tuition was $64,000 a year, and our father's situation had changed the financial calculus of the entire family. She did not ask me directly. That was not Diana's way. She explained the situation with the careful precision of someone who had rehearsed the explanation. And then she went quiet, and the silence did the asking for her. I told her I would cover it. 2 years of tuition. $128,000. I withdrew it from the account I had been building the prototype with, and I wired it to her in 2 installments without telling our mother. Because our mother would have refused on principle, and Diana would have been caught in the middle. I went back to working on Axiom with what was left. I want to be honest about something. I did not resent it at the time. That is the truth, and it matters. I made that decision freely, and I would make it again. because Diana was brilliant, and the MBA was going to give her tools she genuinely needed. And I genuinely believed, that we were building something together. That the investment I was making in her was an investment in both of us. What I did not understand then, and would not understand for several more years, was the difference between someone who believes in you and someone who believes in what you can do for them. It is a subtle difference. From the inside, it feels identical. Axiom came together in the final 3 months of my second year. The core breakthrough was a compression algorithm that reduced latency in multi-asset risk modeling from an industry average of 4 to 11 seconds down to 312 milliseconds. I had the prototype validated by 2 independent quants, who both told me, separately and unprompted, that they had never seen anything like it. I incorporated Vertex Tech LLC in my own name on a Thursday morning. That afternoon, I called Diana. She drove over that same evening, and I walked her through the system for 2 hours. She asked sharp, intelligent questions. She understood the commercial implications immediately, faster than I expected, actually, which told me her MBA had given her exactly what I had paid for. When I finished, she looked at me for a long moment and said, "You need someone who can run the business side. You'll disappear back into the code the moment there's a client to manage." She was right. She said, "Let me do it." I said, "I was going to ask you." We shook hands in my kitchen like we were closing a deal. And then we both laughed, because it felt absurd and right at the same time. That was the last uncomplicated moment I can remember between us. The first time I met Marcus Hayes, he was 40 minutes late to his own interview. Diana had recommended him for the COO position 18 months after Vertex Tech signed its 4th institutional client. We were growing faster than either of us had anticipated, and Diana argued, correctly, that we needed an operations lead who could manage vendor relationships, staffing, and the administrative infrastructure that I had no interest in and no talent for. She sent me his resume on a Tuesday. Marcus Hayes. 11 years in financial operations, 2 stints at mid-size asset management firms, an MBA from Northwestern. On paper, he was qualified. In the margin of the email, Diana had written, "I think he's the one. Trust me on this." I scheduled the interview for 9 in the morning. He arrived at 9:40. He did not apologize. He walked in, shook my hand with the particular grip of a man who has been told that a firm handshake communicates dominance, and said, "Traffic on the 90 was brutal this morning. You know how it is." I did not know how it was, because I had left my apartment at 7:30 specifically to avoid it. I hired him anyway. Because Diana vouched for him, and because his operational instincts during the interview, once he arrived, were genuinely sharp. And because I made the same mistake I had been making my entire adult life. I trusted the people I loved to know the people they recommended. That was the third mistake. Victor Langley came next. Victor was Diana's cousin on our mother's side, a connection I had never paid much attention to growing up, because Victor had always existed at the comfortable periphery of family events. The kind of person who was always present, but never quite central. He was smooth in the way that people are smooth when they have learned early that charm is more efficient than effort. Diana brought him in as Director of Communications 8 months after Marcus joined. I did not interview Victor. Diana handled it. She presented it to me as a done deal. "I've already walked him through the role, Ethan. He's perfect for it." And I was deep in a second-generation rewrite of Axiom's core compression module at the time, and I said yes, without looking up from my screen. I think about that moment more than I probably should. My mother, Margaret Brooks, had her own relationship with Vertex Tech that was harder to define, and in some ways, harder to forgive. She had never understood what I built. Not technically. That was fine. I did not expect her to understand the engineering. I mean, she never understood the significance of it. To Margaret, Vertex Tech was Ethan's computer thing, and Diana was running the business side. and the distinction between the two, between the man who built the engine and the woman who drove the car, had never registered as meaningful to her. Diana had always been Margaret's favorite. This was not a secret, and it was not a wound I carried with particular bitterness. It was simply a fact of the Brooks family geography. Diana was warmer, more social, more present at the holidays. She called Margaret every Sunday. She remembered the names of Margaret's friends. She showed up. I built things in the dark and forgot to call. I understood the math of my mother's affection. I had accepted it a long time ago. What I had not anticipated was the way that preference would harden into something more dangerous when the money became real. By the time Vertex Tech hit its third year of operation, the ecosystem had taken shape around me so gradually that I had not noticed it happening. Marcus ran the operational side with a confidence that had grown, I realized in retrospect, in inverse proportion to the oversight I provided. Victor managed the company's external messaging in ways that increasingly centered Diana's name and leadership. Margaret attended company events as a kind of unofficial ambassador, glowing about Diana's company to anyone who would listen. And I was in my office, rewriting code. I want to be precise about something, because it matters for what comes later. None of this happened through a single act of conspiracy. There was no meeting in a back room where Marcus and Victor and Diana sat around a table and designed a plan to erase me. What happened was slower and more human than that. It happened through 100 small decisions, 100 small omissions, 100 moments where someone chose to let an inaccuracy stand because correcting it was inconvenient. That is how legacies get stolen. Not in one dramatic moment, in the accumulation of small silences. I did not see it clearly until the morning Diana's attorney filed the motion that classified Axiom as a corporate asset. That was the morning I understood that the Hall of Wolves had been built one room at a time, and I had handed them the keys. But I had also, quietly and without announcement, kept a copy of the blueprint. The letter arrived on a Monday. Not digitally, not through Mr. Coleman's office. It came the old way. A sealed envelope delivered by a courier to my apartment door at 7:15 in the morning, before I had finished my first cup of coffee. The return address was Hartley and Associates, Diana's legal team. The envelope was thick. The kind of thick that tells you someone has been preparing for a long time. I opened it at my kitchen table. The cover letter was 3 paragraphs. Precise, professional, bloodless. It informed me that Vertex Tech LLC was initiating formal proceedings to establish sole corporate ownership of Axiom and all associated intellectual property, effective immediately. It cited 3 legal theories: work-for-hire doctrine, joint development with corporate funding, and implied license transfer through years of corporate deployment. The final paragraph contained the settlement offer, $80,000. I read the letter twice. Then I folded it carefully along its original crease, placed it back in the envelope, and set it on the corner of my kitchen table, where it sat for the rest of the morning while I finished my coffee and watched the light change over the city. I was not angry. Not yet. What I felt in that moment was something closer to recognition, the particular sensation of a pattern completing itself, of watching the last piece of something you had half suspected for a long time finally slide into place. I called Mr. Coleman at 9 o'clock. Daniel Coleman had been my attorney for 4 years. He was 63, semi-retired, with a background in intellectual property law and the unhurried manner of a man who had spent decades watching people underestimate the documents they had signed. He was the kind of attorney who never raised his voice in a courtroom, because he never needed to. I read him the letter over the phone. When I finished, there was a pause. "Well," he said, "she moved faster than I expected." "You expected this? I told you 8 months ago that the way she restructured the executive agreements created exposure. You remember that conversation." I remembered it. "So," he said, How do you want to handle it? I told him what I wanted to do. There was Ethan, he said carefully. If you suspend the license, you will shut down their entire operation. Every client contract, every active deployment, every institutional relationship they have built for 3 years. All of it stops. I know, I said. The financial exposure for Vertex Tech will be significant. We are talking potential breach of contract claims from clients, regulatory scrutiny, possible injunctions. I know that too. And you understand that once you do this, there is no quiet resolution. This becomes a full legal war. It already is, I said. They just forgot to tell me. I packed a bag that afternoon. Not because I was running. I want to be clear about that. I packed a bag because I knew what the next 48 hours were going to look like once the suspension notice hit Diana's legal team. And I had no interest in being accessible for the chaos that would follow. I needed a place to think. A place where no one from Vertex Tech or the Brooks family could arrive at my door unannounced. I drove to the Riverside Inn. It was a $40 a night motel on the western edge of the city. The kind of place with a vending machine in the hallway, and a shower that took 3 minutes to run warm, and curtains that did not quite meet in the middle. I had stayed there once before, years ago, during a stretch when I was between apartments and working 18-hour days on the first Axiom prototype. I knew the owner. I paid cash. Room 11, second floor. View of the parking lot, and beyond it, a strip of dark river visible between 2 warehouses. I set my laptop on the desk, opened the LLC operating agreement to the licensing clause, and read it one more time, even though I already knew every word. Section 7.4. License Revocation. Licensor retains the unilateral right to revoke, suspend, or modify any license granted under this agreement upon written notice of not less than 24 hours for any reason at licensor's sole discretion. 24 hours. I drafted the suspension notice at 4:17 in the afternoon. It was 1 page. It cited Section 7.4. It was addressed to Diana Brooks Hayes, Chief Executive Officer, Vertex Tech LLC, and copied to all 7 of the company's active institutional clients. I read it once more. Then I attached it to an email, moved my cursor to the send button, and held it there for approximately 30 seconds. I thought about the kitchen in Evanston, about my father's hand on my arm the night I showed him the first working prototype, about Diana's face when she said, "This is going to change everything." I thought about the envelope on my kitchen table. I clicked send. At 4:22 in the afternoon, the Axiom system went offline across 437 active client endpoints simultaneously. I closed the laptop. I sat in the chair by the window and watched the river in the gap between the warehouses until the light went out of the sky. I did not sleep well that night. Not because of guilt. I want to be precise about that, because the distinction matters. I had made the decision at the kitchen table in the morning, and I had executed it in the afternoon, and I stood behind it completely. What kept me awake in room 11 of the Riverside Inn was not doubt. It was the particular alertness of a man who has just changed the pressure in a sealed room and is listening for the sounds that follow. They started at 6:43 in the morning. My phone lit up on the nightstand, not with a call, but with an email notification. Then another. Then 3 more in rapid succession. I picked it up and scrolled through them without sitting up. The first was from a compliance officer at Meridian Capital Partners, one of Vertex Tech's oldest institutional clients. The subject line read, "Urgent. Axiom system outage. Requesting immediate escalation." The tone was professional, but tight. The kind of tight that precedes a legal threat by approximately 48 hours. The second was from their counterpart at Lakeshore Institution. The third was from 2 others I recognized. The fourth was from Diana. I read Diana's email last, which I suspect she would have found infuriating if she had known. It was 9 paragraphs long. The first 3 were legal language, almost certainly drafted by Hartley or one of his associates. Formal notice that the suspension was unauthorized, that it constituted tortious interference with Vertex Tech's contractual obligations, and that she was pursuing an emergency injunction effective immediately. Paragraphs 4 through 7 were Diana. I could tell because the syntax changed. The controlled precision of the legal language gave way to something faster and less careful. The way writing changes when the person holding the pen is genuinely frightened. She wrote that I was destroying everything we had built. She wrote that clients were calling her personal cell phone. She wrote that Marcus had been in the office since 4 in the morning trying to manage the fallout, and that 3 of their 7 institutional accounts had already initiated formal complaint procedures. Paragraph 8 was a single sentence. Ethan, please, just call me. Paragraph 9 was the legal signature block. I sat the phone face down on the nightstand and stared at the ceiling for a while. Mr. Coleman called at 7:15. I assume you've seen the emails, he said. Some of them. Hartley filed for an emergency injunction at 6 this morning. Judge Morris's clerk pushed it to a preliminary hearing Thursday. That gives us 3 days. That's enough time, I said. It is, Coleman said. I also received a call at 6:50 from a man named Richard Hartwell. He represents Nexus Capital. I sat up. Nexus Capital was the private equity firm that had been conducting preliminary acquisition discussions with Vertex Tech for the past 4 months. An $80 million deal, contingent, as all such deals are, on the target company's legal and operational stability. What did he say? I asked. He said the Axiom outage triggered an automatic review clause in their letter of intent. He wants documentation on the ownership dispute within 72 hours, or Nexus walks. I was quiet for a moment. Good, I said. Coleman paused. You wanted this. I wanted the truth to be visible, I said. Nexus seeing the ownership question directly is the fastest way to make that happen. By noon, the picture had come together in ways I had anticipated, and a few I had not. Marcus had sent a company-wide email at 5:47 in the morning informing Vertex Tech's 42 employees that the system outage was due to a licensing dispute with a third-party vendor and was being resolved. The phrase third-party vendor landed in my chest with a weight I had not expected. I had written the code that those 42 people built their careers on. I had designed the system they logged into every morning. I was, in Marcus's language, a third-party vendor. I wrote the phrase down in the small notebook I kept on the desk, not because I needed to remember it, because I wanted to look at it clearly. Victor had posted a statement on Vertex Tech's website and LinkedIn page by 10 in the morning. A carefully worded paragraph about temporary service interruptions and ongoing system maintenance, accompanied by assurances of full restoration within 24 to 48 hours. There were no assurances he could make that were true. Axiom was not coming back online in 24 hours. It was not coming back online until I decided it was coming back online. And I had not decided that yet. At 2 in the afternoon, my phone rang with a number I did not recognize. I answered it out of instinct. Mr. Brooks. A woman's voice. Calm, measured, precise. My name is Sandra Reeves. I'm a senior analyst at Meridian Capital. I'll be direct with you. We've been trying to reach Vertex Tech's leadership since 6 this morning, and we're getting managed statements instead of answers. We understand there may be a fundamental ownership question with the Axiom system. If that's accurate, we need to know who we should actually be talking to. I looked out the window at the parking lot. A thin rain had started at some point without my noticing. You're talking to him, I said. There was a brief silence. I thought so, she said. Could we schedule a call for tomorrow morning? Yes, I said. 7 o'clock. We'll be there, she said, and hung up. I put the phone down and allowed myself, for the first time since the previous afternoon, one small, quiet moment of something that was not quite satisfaction, but was close enough to recognize. The right people were beginning to ask the right questions. On the second morning at the Riverside Inn, I drove to Evanston. I had not planned to. I had a call with Sandra Reeves at Meridian Capital at 7 o'clock, which went better than I had any right to expect, and a follow-up with Mr. Coleman at 9, and a list of documentation tasks that needed to be completed before Thursday's preliminary hearing. My day was full. There was no logical reason to make a 40-minute drive to my mother's house, but there was one thing I needed that I could not get anywhere else: the development notebooks. 4 of them. Spiral-bound, black cover, college ruled. I had filled them over the course of Axiom's first 2 years. Equations, architecture diagrams, compression logic, handwritten annotations in the margins where the typed notes could not keep up with the thinking. Every major decision in the system's design existed first in those notebooks, in my handwriting, dated and sequential and entirely irreproducible. Mr. Coleman had asked me about them 3 months ago, when the first signs of Diana's legal strategy had become visible. I had told him they were in storage at my mother's house in Evanston. In a green plastic bin on the second shelf of the garage, exactly where I had left them 4 years ago when I moved out of the apartment and had no room for anything that was not essential. He had said, "Get them." I had kept meaning to. I had kept not doing it. I drove to Evanston. My mother answered the door in her bathrobe. It was 10:40 in the morning. She looked at me the way she had been looking at me since Diana's legal team filed the initial motion. Not with anger exactly, but with a kind of weary disappointment, as though my existence had become an inconvenience she had not budgeted for. "Ethan," she said. Not a greeting, a statement of fact. "Good morning, Mom. I need to get something from the garage." She did not move from the doorway for a moment. Then she stepped aside. The house was quiet. It had the particular quiet of a place that used to hold more life than it currently did. My father's reading chair was still in the corner of the living room. His reading glasses were still on the side table beside it. 14 months, and no one had moved them. I did not stop walking. The green bin was exactly where I had left it. I pulled it down from the shelf and opened it on the garage floor. And there were the notebooks. All 4 of them, dry and undisturbed, exactly as I remembered. I checked the dates on the covers out of habit. First notebook, March, year 1. Fourth notebook, November, year 2. Every page of Axiom's origin, in sequence, in my hand. I was placing them carefully into the canvas bag I had brought when I heard my mother's footsteps on the garage steps. "Diana called me last night," she said. I kept packing. "She said you shut down the company. She said you're trying to destroy everything she built." I straightened up and looked at her. Everything she built, Ethan. "I'm not going to have this conversation, Mom." She was quiet for a moment. Then she said, with a precision that surprised me, "Your father would not have done this." I held her gaze for a count of 3. Then I picked up my bag and turned toward the door. "Actually," I said, "I think you're wrong about that." I was almost to my car when she called after me. "There's something in the house. For you." Her voice had changed, the edge gone out of it, replaced by something more tired. "Your father left it, with the estate documents. He told the lawyer it was for you specifically. He said—" She stopped, started again. "He said you'd know when to open it." I turned around. She was standing at the top of the garage steps, arms crossed over her bathrobe, looking smaller than I remembered her looking. Behind her, through the open door, I could see my father's reading chair. "Where is it?" I said. She went inside. I followed. She retrieved a manila envelope from the drawer of my father's desk, the old oak desk he had kept in the study for 30 years, the one with the sticky second drawer and the brass lamp that had needed a new bulb since approximately the Clinton administration. The envelope was sealed. On the front, in my father's handwriting, careful, architectural, the handwriting of a man who had spent his life making precise marks on paper, were 4 words: "For Ethan." Not yet. I sat in my car in my mother's driveway for a long time. The envelope was on the passenger seat. I looked at it twice, I picked it up once and held it and set it back down. Not yet. My father had known something. I did not know what he had known or how much, but the man who had built load-bearing frameworks his entire career had understood, in whatever way fathers understand these things, that his son was going to need something solid to stand on before this was over. I started the car. I drove back toward the city with the envelope on the seat beside me and 4 notebooks in the bag behind me, and something that felt, for the first time in a long time, like I was not entirely alone in this. On the 3rd morning, Mr. Coleman came to me. Not a phone call. He drove to the Riverside Inn, knocked on the door of room 11 at 8:15, with a cardboard box under one arm and a coffee from the place 2 blocks down that I had not known existed, and sat down at the small desk by the window, like a man who had something to show me that required a table. I moved the father's envelope to the nightstand to make room. Coleman did not ask about it. He set the box down, opened it, and began laying documents on the desk in a sequence that told me, before he said a single word, that he had not slept much either. Forensic accounting, he said. I retained Patricia Hale on Monday. She finished her preliminary review last night. Patricia Hale was a certified fraud examiner who had spent 11 years with the FBI's Financial Crimes Unit before going private. Coleman had mentioned her once, months ago, in the context of a hypothetical. I had filed the name away. What did she find? I asked. Coleman sat down and folded his hands on the desk. More than I expected, he said, and I expected quite a bit. The first pattern was in the R&D allocations. Vertex Tech had maintained a research and development budget since its 2nd year of operation. Initially modest, growing to approximately $400,000 annually by year 4. The budget was managed by Marcus, in his capacity as COO, with Diana's executive sign-off. Standard corporate structure, entirely normal on the surface. What was not normal was where the money went. Patricia Hale had traced 3 separate tranches of R&D disbursements, totaling $263,000 over 22 months, to a limited liability company registered in Delaware under the name Bridgewater Analytics Group. Bridgewater Analytics Group had no employees, no website, no registered business address, and no clients. It had one owner, Marcus Hayes. Coleman slid the incorporation document across the desk. I looked at it for a moment without touching it. He was billing the company for services that did not exist, I said. Billing through a shell, Coleman said. Properly structured to survive a casual audit. It would have gone undetected indefinitely if Hale hadn't been specifically looking for disbursement anomalies. Does Diana know? Coleman was quiet for a moment. That, he said, is the question that matters most. And the answer is probably somewhere between yes and not entirely, which in a federal context is nearly as problematic as yes. The second pattern was different in nature, but equal in significance. In the 14 months since my father's death, the same 14 months during which Diana had been quietly restructuring Vertex Tech's executive agreements and building her legal case against me, the company had made 6 real estate-related disbursements classified under the category of corporate facilities and infrastructure. 2 of them were legitimate, a lease renewal and a server room upgrade. The other 4, totaling $341,000, traced to a residential property purchase in Lincoln Park, a condominium, registered in Diana's personal name. The condominium was currently valued at $1.2 million. I sat back in the chair. She used corporate funds to buy personal property, I said. She used corporate funds to make the down payment and 4 months of carrying costs on personal property.
Coleman said precisely.
And then reclassified the disbursements as facilities expenditures during the annual audit review. Outside the window, the parking lot was empty except for a pickup truck with a cracked taillight. A pigeon was walking along the roof of the truck with the unhurried confidence of an animal that had never once considered consequences. She was doing this, I said slowly, at the same time she was building the case to take Axiom from me. Yes. which means she needed the IP transfer to succeed specifically because the company's balance sheet could not survive a forensic review, Coleman finished. The acquisition offer from Nexus Capital was not just desirable, it was necessary. The acquisition would have closed the books, distributed proceeds, and buried the forensic trail under a completed transaction. I thought about that for a moment. A $75 million acquisition. A clean exit. And underneath it, $263,000 in shell disbursements and $341,000 in misclassified real estate expenditures. Diana had not just been trying to take Axiom. She had been trying to escape what she and Marcus had already done. The lawsuit against me was not the primary move. It was the cover. What does this do to Thursday's hearing? I asked. It changes the nature of the proceeding entirely, Coleman said. We are no longer arguing asset ownership in a family court context. We are presenting evidence of coordinated financial fraud, potential wire fraud given the interstate banking elements, and breach of fiduciary duty. I will be filing a motion to consolidate with a federal track by end of day. And Nexus Capital? I spoke to Hartwell again this morning. He has extended their documentation deadline by 48 hours. He is watching the proceeding closely. Coleman paused. I told him you would be in New York by Friday. I looked up. There is a conversation you need to have in person, he said. Hartwell is the kind of man who makes decisions based on who is sitting across the table from him. He needs to see you. I thought about the envelope on the nightstand. About Sander Reeves saying, I thought so. About 4 notebooks in a canvas bag and a case that had started as a defense and was becoming, with each passing hour, something considerably more deliberate. Book me a flight, I said. I have never liked flying. Not because of fear. I want to be clear about that distinction, because it matters to how I think about most things. I do not fear the altitude or the mechanics of it. What I dislike is the particular helplessness of being 35,000 feet above the ground, with nothing to do but sit with your own thoughts and wait for the earth to come back. On the flight to LaGuardia, I had approximately 2 hours and 11 minutes of that. I spent the first 40 minutes reviewing the financial forensics Patricia Hale had compiled. I spent the next 30 reading through the Nexus Capital letter of intent that Coleman had forwarded. A 43-page document written in the precise, layered language of people who had spent considerable time ensuring that every word meant exactly what they intended and nothing more. I spent the remaining time looking out the window at the flat, gray expanse of Lake Michigan, giving way to Pennsylvania, and then the dense northeastern corridor bleeding into New York. The father's envelope was in my carry-on bag. I had not opened it. Richard Hartwell's office was on the 34th floor of a building on Park Avenue that had the kind of lobby designed to make you aware, before you had spoken a single word to anyone, of exactly how much everything in it cost. Marble floors, a security desk staffed by 2 men in suits who checked credentials with the unhurried efficiency of people who had never once been rushed by anyone waiting behind them. I arrived 12 minutes early. I sat in a chair by the window and watched the city move 40 stories below, and thought about my father, who had spent 31 years building the frameworks inside buildings like this one, the load-bearing structures buried in the walls that nobody ever thought about until something went wrong. At exactly 9 o'clock, a young woman came to collect me. Hartwell was 61, silver-haired, with the compact stillness of a man who had learned decades ago that the person who speaks least in a room usually leaves with the most. He stood when I entered, shook my hand once, and gestured to the chair across from him without ceremony. There was a third person in the room. He was seated to Hartwell's left. Older, perhaps 70 or 71, with the careful posture of someone who had once been broader through the shoulders and had not entirely reconciled himself to the narrowing of age. He wore a charcoal suit that had been expensive a long time ago and was still quietly distinguished. He did not stand when I entered. He looked at me with the particular attention of a man who already knows the answer to the question he is about to ask. "Mr. Brooks," Hartwell said, "I'd like you to meet Harold Chen." Harold was a senior partner at the firm that conducted Vertex Tech's first independent technology audit 3 years ago. I looked at Harold Chen. Harold Chen looked back at me with something that was not quite a smile, but occupied the same neighborhood. "I know who you are, Mr. Brooks," he said. His voice was unhurried, slightly graveled, the voice of a man who had stopped trying to sound like anything other than what he was. I have known for approximately 3 years. What Harold Chen told me over the next 40 minutes rearranged several things I had believed to be true. 3 years ago, his firm had been retained to conduct a technical due diligence audit of Axiom as part of Vertex Tech's Series A preparation. Standard procedure. The audit was supposed to establish the system's technical provenance, essentially confirm that the IP was clean, original, and owned by the entity claiming to own it. Harold had led the audit personally. What he found was unambiguous. The development timeline, the architecture signatures, the compression logic, all of it traced to a single engineer working independently prior to Vertex Tech's incorporation. The LLC licensing structure was explicit. The ownership was not in question. He had written exactly that in his preliminary report. Diana had called him the following week. "She asked me," Harold said carefully, "to reconsider the framing of the ownership section. She suggested that a more corporate-oriented characterization of the development history would better serve the company's fundraising narrative." The room was quiet for a moment. "She asked you to alter your findings," I said. "She asked me to reframe them." He paused. I declined. She retained a different firm for the final audit. He reached into the leather folio on the table in front of him and produced a document, 12 pages, bound, with his firm's letterhead and a date stamp from 3 years ago. "This is the preliminary report," he said. "The one that was never submitted. I kept a copy." He slid it across the table toward me. "I kept it because in 31 years of this work, I have learned that the truth has a way of needing somewhere to go. Eventually." I picked up the report and held it, and did not say anything for a moment. 31 years, the same number my father had given to his work. I thought, "Mr. Chen," I said, "would you be willing to provide this as a sworn declaration in a legal proceeding?" He had clearly been waiting for the question. "That," he said, "is precisely why I am in this room." Hartwell spoke for the first time since the introduction. "Given Mr. Chen's documentation and your LLC filing history, Nexus Capital is prepared to redirect the acquisition conversation." He opened a folder of his own. "We are no longer interested in acquiring Vertex Tech. We are interested in a long-term licensing agreement for Axiom directly, with you, Mr. Brooks, as the sole licensing party." He slid a term sheet across the desk. The number at the top was $95 million. I read the full page before I responded. I read it the way my father had taught me to read any document that mattered. Slowly, completely, without letting the largest number on the page crowd out the details surrounding it. Then I looked up at Hartwell. "I will have my attorney review this by end of week," I said. Hartwell nodded, as though he had expected nothing less. As I stood to leave, Harold Chen rose with me. He extended his hand, and when I took it, he held it for a moment longer than a standard handshake. "Your father was a good man," he said quietly. I looked at him. "Raymond Brooks." He said my father's name with the ease of someone who had known it for a long time. "We were in the same professional association for years. He talked about you." A brief pause. "He was very specific about what he believed you had built." I did not trust my voice entirely in that moment, so I simply nodded. I walked out of the building and onto Park Avenue and stood on the sidewalk in the cold November air while the city moved around me in every direction at once. Indifferent and enormous, and entirely unaware that something had just shifted. $95 million. Harold Chin's report. And somewhere in my carry-on bag, a sealed envelope from a man who had apparently known, long before I did, exactly how this was going to go. I landed back in Chicago at 6:48 in the evening, the day before Thanksgiving. O'Hare was the particular kind of crowded that only exists the night before a national holiday. Families moving in dense clusters through the terminal, children running ahead of adults who had stopped pretending to keep up. A specific quality of tired happiness that belongs to people who are going somewhere they actually want to be. I moved through it with my carry-on and my 4 notebooks and my father's envelope, and found my car in the long-term lot and drove back toward the city in the dark. I did not have anywhere to be for Thanksgiving. This was not a new condition. For most of the past 6 years, the holiday had been a variable I managed around, rather than a day I experienced. Sometimes dinner at my mother's house in Evanston. Sometimes a brief appearance at whatever gathering Diana had organized for the extended family. Always with the faint awareness that I was performing attendance rather than feeling it. The last Thanksgiving I remembered clearly was the one 2 years before my father died, when he and I had sat on the back porch after dinner while everyone else was inside. And he had asked me, without preamble, how I was really doing. I had told him the truth. Not all of it, but more than I told most people. He had listened without interrupting, which was the thing he did that I had never adequately thanked him for. I checked back into the Riverside Inn out of a habit I had not examined closely enough to justify. Room 11 was available. The owner, a compact Vietnamese-American man named Philip, who had run the place for 22 years and asked questions with his eyes rather than his mouth, handed me the key without comment and went back to his paperwork. I bought a turkey sandwich from the gas station 2 blocks down. I ate it at the desk in room 11, with the forensic documents spread to one side and the $95 million term sheet on the other. And I thought about the fact that this was, objectively, not a bad Thanksgiving. I had more clarity than I had possessed at any point in the past 3 years. I knew what I was fighting. I knew how I was fighting it. And for the first time since Diana's attorney had filed the initial motion, I could see the shape of the ending. Coleman called at 8:17. Nexus Capital served the notice this afternoon, he said. Formal termination of the letter of intent with Vertex Tech, effective immediately. Citing unresolved IP ownership dispute and material misrepresentation in the acquisition disclosures. A pause. They sent it by process server to Diana's home address. I set down the second half of my sandwich. On Thanksgiving, I said. Hartwell is not a sentimental man, Coleman said. There was something in his voice that was not quite satisfaction, but lived close to it. Diana had 17 people at that house for the holiday. Her attorney, Marcus, Victor, your mother. The server knocked at 4:15 in the afternoon. I thought about that image for a moment. Diana's Lincoln Park condominium, the one purchased partly with Vertex Tech's misclassified funds, full of family and catered food and the performance of a successful life. And then a knock at the door at 4:15 that made every person in that room understand, without being told, that something had gone irreversibly wrong. How did she respond? I asked. Hartley called me at 4:42 and used language I won't repeat, Coleman said. But the substance was that they intend to file an emergency motion Monday claiming the Nexus termination was induced by our interference. Can they make that argument? They can make any argument they want, Coleman said pleasantly. Making it and surviving it are different exercises. After I hung up, I sat by the window for a while and watched the parking lot. Philip had put a small artificial wreath on the door of the office downstairs. Orange and brown, the colors of the season, slightly lopsided on its nail. A car pulled in around 9 o'clock and a family got out. 2 adults, 3 children. Everyone moving with the slow exhaustion of people who had been driving for a long time and were relieved to have stopped. The youngest child, maybe 4 years old, walked across the parking lot, holding both arms out slightly from her sides, the way small children do when they are navigating a surface they are not entirely certain of. I watched until they went inside. There are things you notice when you are alone on a holiday that you do not notice when you are not. The way an ordinary moment, a child crossing a parking lot, a wreath on a door, can carry a weight that has nothing to do with the moment itself, and everything to do with what you are carrying when you see it. I was not sad. I want to be clear about that. What I felt was quieter than sadness and more durable. Something closer to the particular peace of a man who has stopped pretending that the situation is other than what it is, and found, on the other side of that honesty, something that functions like solid ground. I opened the 4th development notebook before I went to sleep. November, year 2. The final 3 months of Axiom's construction. My handwriting from that period was tighter than usual. Compressed, fast, the handwriting of someone who knew they were running out of time and space simultaneously. Page after page of logic gates and compression ratios and margin notes to myself in shorthand that I could still read perfectly. On the last page of the notebook, I had written a single line that I did not remember writing. Build it so well, they cannot pretend it was never yours. I sat with that for a long time. Then I closed the notebook, turned off the light, and let the first genuinely quiet night in 2 weeks settle over room 11 of the Riverside Inn. What I did not know, lying there in the dark on the night before Thanksgiving, was that 3 miles away, in a glass and steel office building in the Loop, Marcus Hayes was not sleeping either. He was making a phone call he would spend the rest of his life wishing he had never made. The Friday after Thanksgiving was cold and gray and absolutely still. Chicago in late November has a particular quality of quiet that is different from other cities. The kind that settles in after a holiday when the restaurants are closed and the streets have not yet decided what to do with themselves. I was up at 6. I ran 4 miles along the river path behind the motel, which I had not done in 3 weeks, and came back to room 11 with cold hands and clearer thinking than I had managed in days. Coleman, Patricia finished the full package last night, he said. I'm on my way to you. He arrived 40 minutes later with a banker's box, a legal pad, and the focused energy of a man who had been waiting to have a particular conversation for longer than was comfortable. He set the box on the desk, opened it, and said, 3 layers. I want to walk you through all of them in sequence, because the sequence matters for how we present this. I pulled my chair to the desk and listened. The first layer was Bridgewater Analytics Group. Patricia Hale had now completed the full trace. Over 22 months, Marcus had routed $263,000 from Vertex Tech's R&D budget through Bridgewater and into a personal investment account registered in his wife's maiden name in a bank in Indianapolis. The wire transfers crossed state lines on 11 separate occasions. Each transfer was under $50,000, a threshold Marcus had clearly understood to be meaningful, which itself demonstrated premeditation. Coleman placed the wire transfer records on the desk in chronological order. 11 pages. Dates, amounts, routing numbers, destination accounts. Clean, sequential, undeniable. The Indianapolis account, Coleman said, was open 9 days after Marcus joined Vertex Tech. I looked at the date on the first transfer, then at the incorporation date of Bridgewater Analytics, then at Marcus's start date at the company. The preparation had preceded his first week on the job. He had walked in the door with the architecture already built. The second layer was the Lincoln Park condominium. Patricia had pulled the full disbursement trail. 4 transactions totaling $341,000, routed through Vertex Tech's facilities budget, and applied to the purchase and carrying costs of a residential property in Diana's name. The reclassification had been executed during the annual audit review by someone with executive-level access to the accounting system. Diana had that access. Marcus had that access. No one else did. Can we establish who executed the reclassification specifically? I asked. The system logs show Diana's credentials, Coleman said, which means either she did it or she gave someone her login. Both are legally problematic. Or Marcus used her credentials without her knowledge. Also possible. Coleman paused. And if that is the case, she is a victim of Marcus as much as you are, which complicates the moral picture considerably. I sat with that for a moment. I had not allowed myself to think too carefully about the moral picture. It was easier and more legally useful to keep the analysis clean and factual. But Coleman was right. The possibility that Diana had been, in some dimension of this, as used as I had been. It did not change what she had done to me, but it added a layer to the story that I had not fully examined. I filed it and moved on. The third layer came from a source Coleman introduced carefully. I received an anonymous text message yesterday evening, he said, from a number that traces to a prepaid phone purchased in cash at a Walgreens in Wicker Park. The message contained specific information about a phone call Marcus made Wednesday night, the night before Thanksgiving. He turned the legal pad toward me. The text, transcribed in Coleman's handwriting, was 7 lines. It described Marcus placing a call at 11:52 Wednesday night to a man referred to only as a document specialist. The call lasted 19 minutes. The subject of the call was the preparation of a backdated IP transfer agreement, a document that would purport to show Ethan Brooks had voluntarily assigned Axiom's intellectual property rights to Vertex Tech 18 months prior to the current proceedings. A forged transfer document. If submitted as evidence, it would constitute perjury, fraud upon the court, and obstruction of justice. Under federal statutes, each charge carried a potential sentence of 5 years. I read the 7 lines twice. Do we know who sent this? I asked. I have a reasonable idea, Coleman said. I am choosing not to confirm it, because the source's safety is better protected by not knowing than by knowing. What matters is that the information is specific enough to be actionable and is consistent with everything Patricia has already established about Marcus's pattern of behavior. Coleman filed the federal motion at 2:17 that afternoon. It cited wire fraud under 18 U.S.C. Section 1343, fraud upon the court, and breach of fiduciary duty. It named Marcus Hayes as primary defendant and Diana Brooks Hayes as co-respondent, with the qualification that Diana's specific knowledge and intent remained to be established. It attached Patricia Hale's complete forensic package as Exhibit A, Harold Chen's suppressed audit report as Exhibit B, and the Nexus Capital termination notice as Exhibit C. It was 48 pages long. Coleman sent me a copy at 2:22. I read the first page, the summary section, and the conclusion. Then I closed it and sat at the window for a while. There is a particular feeling that arrives when something you have been building for months is finally complete enough to stand on its own. Not pride exactly, something quieter. The feeling of having done a thing correctly, the way it needed to be done, without cutting corners or losing patience, or letting the anger that lived underneath all of this make a single decision on your behalf. I had built it so well, they could not pretend it was never mine. My phone buzzed at 4:45, a text from a number I recognized. Victor Langley. Ethan, she needs to talk to you. Please. She's coming to find you. I looked at the text for a long moment. Then I looked out at the parking lot. 40 minutes later, a silver Mercedes I recognized pulled in off the street and parked crookedly in the spot nearest the office. The driver's door opened, and Diana Brooks Hayes stepped out into the November cold without a coat, which told me everything I needed to know about the state she was in. She looked up at the second floor. She found my window. I heard her footsteps on the exterior staircase before she knocked. I recognized them the way you recognize things you have known your entire life, without ever consciously cataloging them. The particular weight and rhythm of your sister's walk, unchanged since she was 12 years old and running up the stairs of the house in Evanston to tell you something she could not wait to say. She knocked twice. Not hard, The knock of someone who was not entirely certain they had the right to be there. I opened the door. Diana stood in the hallway in a gray sweater and dark slacks and no coat. Her arms wrapped around herself against the cold she had apparently not thought to prepare for. Her hair was down, which was unusual. Diana, in any professional or semi-professional context, wore her hair up with the same consistency that she wore her composure. The hair down meant the composure was somewhere else tonight. She looked at me for a moment without speaking. I stepped back from the door. She came in. The room looked exactly like what it was. A $40 motel room occupied by a man in the middle of the most consequential legal battle of his life. Documents on the desk. 4 notebooks stacked by the window. A coffee cup from that morning that I had not thrown away. The father's envelope on the nightstand, exactly where it had been since Evanston. Diana's eyes moved across the room, the way eyes move when they are cataloging rather than looking. They stopped on the nightstand. "Is that from Dad?" she said. "Yes." She was quiet for a moment. "Did you read it?" "Not yet." The 2 words settled into the room like something physical. Diana looked at the envelope for another second, then looked away, and I understood from the way she did it that the envelope meant something to her she was not prepared to discuss. She sat in the chair by the window without being invited to. I sat on the edge of the desk and waited. "I didn't know about the Indianapolis account," she said. Not as an opening to a larger speech, just a statement, placed carefully in the air between us, like something fragile she was setting down. "Okay," I said. "I'm not asking you to believe that. I'm just telling you. I heard you." She looked at her hands. "Marcus told me the R&D disbursements were going to legitimate vendors. He showed me invoices. They looked real." A pause. "I signed off on them because I trusted him, and because I was managing everything else, and I trusted him." I did not say anything. "Ethan." She said my name the way she used to say it when we were children, and she had done something wrong and knew it, and had not yet decided how to frame the admission. "I know what I did. With the lawsuit, with the IP claim. I know what that was." "What was it?" I said. Not a challenge, a genuine question. I had wondered for months whether she had a name for it inside her own mind. She met my eyes for the first time since sitting down. "It was wrong," she said. Flat. No qualification, no architecture around it. Just the word, standing alone. The room was very quiet. Outside, a car pulled into the parking lot, its headlights sweeping briefly across the ceiling before it went dark. Somewhere down the hall, a television played at low volume. A news channel, the rhythm of a weather forecast. I thought about what I wanted to say and discarded several versions of it before I found the one that was true. "I didn't do any of this to destroy you," I said. "I want you to understand that. Not the suspension, not the filings, not any of it. I did it because it was mine, and I was not going to let it be taken without a fight. That's all." Diana looked at the window, at the dark parking lot and the thin strip of river beyond it. "Dad used to say you were the most stubborn person he had ever met," she said quietly. He meant it as a compliment. "I know." "He also—" She stopped, started again. "He said something to me the last time I saw him in the hospital. About you. About what you'd built." She did not finish the sentence. I did not push her to finish it. Whatever Raymond Brooks had said to Diana in that hospital room, she was not ready to share it. And I had learned, over the past weeks, that there were things that needed to stay sealed until the moment they were ready to be opened. I looked at the envelope on the nightstand. Not yet. Diana stood after a while. She picked up her arms from her sides and then seemed not to know what to do with them, which was the most human I had seen her look in years. "I should go," she said. "Yes." She moved toward the door and stopped with her hand on the frame. She did not turn around. "He left something for me too," she said. "A letter. I haven't opened mine either." Then she walked out, and I listened to her footsteps go back down the exterior stairs. The same weight, the same rhythm. And I stood at the window and watched her cross the parking lot and get into the silver Mercedes and sit there, without starting the engine, for a very long time. She drove away at 9:43. My phone rang at 9:51. "Coleman, I need you to know something before you hear it another way," he said. "Margaret Brooks filed an emergency petition this afternoon with the family court, claiming harassment and intimidation. She is requesting a temporary restraining order against you, effective immediately. The petition was filed at 4 o'clock, about the same time Diana would have been driving to you." I looked at the window where Diana's car had been. "Diana didn't know," I said. It was not a question. "Based on the timing," Coleman said carefully, "that would appear to be correct." Coleman read me the petition over the phone. It was 4 pages. "Margaret Brooks, petitioner, requesting an emergency temporary restraining order against Ethan Raymond Brooks, respondent, in the Circuit Court of Cook County, Illinois. The grounds, as stated, were harassment, intimidation, and a pattern of threatening behavior directed at Diana Brooks Hayes and members of the Brooks family household. The specific allegations were 3. First, that Ethan had suspended Vertex Tech's operating system without warning, causing severe financial and emotional distress to Diana. Second, that Ethan had traveled to the family residence in Evanston under false pretenses, creating an atmosphere of fear and hostility. Third, that Ethan had orchestrated a coordinated campaign of legal and financial pressure designed to psychologically harm Diana and coerce a settlement favorable to himself. Coleman paused after the third one. "The Evanston visit," I said. "You went to retrieve your notebooks," he said. "You were there for approximately 40 minutes. Your mother was present and unharmed. You had a conversation and left." "That is correct." "And the suspension of the operating system was executed pursuant to Section 7.4 of a valid licensing agreement," I said, "which we have already submitted into evidence." "Also correct." A brief pause. "Ethan, I want to be direct with you. This petition is not legally strong. Under Illinois law, an emergency TRO requires a showing of immediate and irreparable harm, credible, specific, and imminent. What your mother has filed describes a business dispute and a family disagreement. No physical threat, no credible danger, no documented pattern of contact." Another pause. Shorter. "What this is a desperate move by a frightened woman who loves her daughter and does not have enough information to understand what she is actually doing." I sat with that for a moment. "What does it cost us?" I asked. "Time. A hearing within 14 days. And the appearance, briefly, of a family in conflict, which Hartley will attempt to use to paint you as an aggressor rather than a plaintiff." He stopped. "What it gives us is considerably more valuable." "Tell me." "It gives us proof of desperation," Coleman said. "A frivolous filing at 4 in the afternoon on the Friday after Thanksgiving, hours after our federal motion landed, while Diana was apparently driving to your motel to have a private conversation. When I present those 2 facts simultaneously to Judge Morris, that Diana sought you out in good faith at the same hour her mother was filing against you, it tells the court everything about the state of their internal coordination." I thought about my mother for a long time after I hung up. Margaret Brooks had been many things in her life. A school teacher for 23 years. A woman who made the same pound cake every Christmas from a recipe she would not write down because she said measurements ruined instinct. A person who had never once, in my memory, done a deliberately cruel thing to anyone. What she was doing now was not cruelty. That was what made it difficult. She was doing what mothers do when they believe one of their children is in danger. She was throwing herself between Diana and the threat, with whatever tools were available to her. without fully understanding the shape of the thing she was throwing herself at. She had filed a restraining order against her own son because she loved her daughter. I could not be angry about that. I had tried, briefly, and found that the anger would not take hold properly, because underneath it was a sadder and more accurate understanding. My mother had always been better at protecting Diana than she had been at seeing me. And that was a fact of my life that I had accepted so long ago it no longer had edges. What I could do was respond correctly. Coleman filed the counter motion at 11:15 that night. Motion to dismiss with prejudice, citing failure to meet the statutory threshold for emergency relief under Illinois Code 735, ILCS 5/11-101. Attached, Riverside Inn registration records confirming Ethan's location for the past 6 days. Flight records, Chicago to LaGuardia and return. The Evanston visit logged against the retrieval of documented development materials already submitted as evidence. A declaration from Philip, the motel owner, confirming Ethan had not left the property between specific hours. Coleman also filed a request for Rule 137 sanctions, the Illinois provision allowing courts to penalize attorneys who file frivolous pleadings, citing the petition's factual inaccuracies and its timing relative to the federal proceedings. Will the sanctions stick? I asked. Probably not on a first filing, he said. But it puts Hartley on notice that we are not going to absorb bad faith actions without response. It changes the cost calculation for whatever they are planning next. After I hung up the second time, I sat at the desk for a while without turning on the light. The room was dark except for the parking lot lamp coming through the gap in the curtains, throwing a pale stripe across the floor. The father's envelope was on the nightstand where it had been for days. I picked it up, which I had done several times, and turned it over, which I had also done several times, and looked at the 4 words on the front. For Ethan. Not yet. Diana had said her copy was also unopened. Raymond Brooks had prepared 2 letters. He had done it, I now understood, not in his final weeks, when illness might have driven sentiment, but with the deliberate foresight of an engineer who identified structural vulnerabilities before they became failures. He had watched Axiom grow. He had watched Diana take the CEO chair. He had watched the ecosystem form around his son without saying directly what he saw. Instead, he had written it down and sealed it. I called the estate attorney at 11:45. His name was Gerald Watts, and he answered on the 4th ring with the unhurried patience of a man who had long since stopped being surprised by late calls. The letters, I said. When did my father prepare them? A brief pause. Papers rustling. The notarization date is March of last year, Watts said. Approximately 18 months before his death. 18 months before his death. 18 months ago, Axiom had just closed its first significant institutional contract. Vertex Tech's valuation was beginning to climb. The executive agreement restructuring that Coleman had identified as the first sign of Diana's legal strategy had begun approximately 14 months ago. My father had written the letters 4 months before Diana started building her case. He had not known exactly what was coming, but he had known something was coming. And he had chosen, with the precision of a structural engineer, to build something that would hold when the weight arrived. I set the envelope back on the nightstand. Not yet. For the first time since Evanston, I thought I understood what those 2 words actually meant. Not a postponement. Not a caution. A timing instruction. The morning before the final hearing, I went through the notebooks again. I found it in the 3rd notebook. He had written 7 lines. Ethan. I unfolded it at the desk. The structure is yours. Make sure the paperwork agrees. Came by Tuesday. You were asleep at the desk again. Didn't wake you. Dad. Not for legal reasons. Coleman had already photographed every relevant page and submitted the documentation. The notebooks as evidence had served their purpose. What I was looking for on that Saturday morning sitting at the desk in room 11 with weak November light coming through the gap in the curtains, was something harder to name. A thread I had not yet pulled. A thing my father had left that I had not yet found. I read it 3 times. The people who stand near something like this will eventually want to say they built it. That's human nature. Don't be surprised when it happens. Be ready. My father's handwriting. The same careful, architectural script from the envelope on the nightstand. Each letter formed with the precision of a man who had spent his career making marks that other people would build from. Be ready. Looked at what you're building for a while. I understand maybe 30% of it, but I understand what it is. It's load-bearing work, the kind that holds everything else up. It was a folded piece of paper tucked inside the back cover. The kind of folded paper that becomes invisible when it is in the right place long enough, that the eye stops registering as separate from the notebook itself. I had opened and closed that notebook dozens of times over 6 years without noticing it. Make sure the paperwork agrees. Tell me, I said. I sat at the desk for a long time without moving. I waited. He had written those words 4 years ago, before Vertex Tech had a single client, before Diana moved into the CEO chair, before Marcus, before Victor, before any of it. I've been thinking about our meeting, he said, without preamble. There is something I did not tell you in the room that I think you should know before tomorrow. Harold Chen called at 10:15, which I had not expected, and which felt, by this point in the week, less like coincidence and more like the story arranging itself. I've been thinking about our meeting, he said, without preamble. There is something I did not tell you in the room that I think you should know before tomorrow. Tell me, I said. Your father called me, Harold said, approximately 2 years before he died, before I conducted the Vertex Tech audit, before any of this. He called me because someone in our professional association had mentioned my work in IP authentication, and he wanted to ask me a question. I waited. He asked me what a person should do if they believed someone they loved was going to claim ownership of something that person had not built. Harold paused. He was hypothetical about it. He never named anyone. But the situation he described was not hypothetical. The November light had shifted slightly, the stripe across the floor moving an inch to the left. What did you tell him? I asked. I told him the same thing I tell everyone, Harold said. Document everything. Date everything. Make sure the legal record reflects the factual record before the dispute, not after it. Another pause, and when he spoke again, his voice had something in it that I had not heard in the Park Avenue office. Something older, quieter. He thanked me, and then he said something I have thought about many times since. He said, I have 2 children. One of them inherited my ability to build things. The other one inherited my ability to recognize what someone else has built and want it near them. Both are gifts, but they are not the same gift, and I am afraid they are going to collide. I did not say anything. He loved Diana, Harold said carefully. I want to be clear about that. He was not condemning her. He was describing her, the way a structural engineer describes a material, not as good or bad, but as what it is, with its specific properties and its specific limitations. Both are gifts, but they are not the same gift. My father had carried that knowledge for years. He had not used it as a weapon, and he had not buried it in silence. He had written it down in 2 letters and sealed them and given them to a lawyer with instructions to release them when his children were ready. He had loved both of his children clearly enough to tell them the truth. He had simply understood that the truth had its own timing. I put the phone down and looked at the envelope on the nightstand for a long time. Not yet. Tomorrow was the final hearing. Exhibit A, Exhibit B, Harold's declaration, Patricia Hale's forensic package, the 4 development notebooks. Everything built. Everything in place. The structure was ready. My phone rang at 4:47. Coleman. His voice was even, which was the voice he used when he needed me to be even. Hartley filed a supplemental exhibit this afternoon, he said. Exhibit C. It purports to be a signed and notarized IP transfer agreement dated 18 months ago, in which you voluntarily assigned all rights to Axiom to Vertex Tech LLC. I looked at the wall. Your signature appears on page 4, Coleman said. I have looked at it carefully. Ethan, you did not sign that document. Coleman sent me the document at 5:11 in the evening. APDF. 4 pages. Headed Intellectual Property Transfer Agreement. Dated 18 months prior, between Ethan Raymond Brooks as transferor and Vertex Tech LLC as transferee. The language was standard, the kind of standard that comes from someone who had looked up an IP transfer template and modified it carefully enough to sound like a real document, but not carefully enough to sound like a document that had actually been negotiated. My signature was on page 4. I looked at it for a long time, not at the signature itself. I knew immediately it was not mine, the way you know your own face in a photograph, and would know instantly if something were wrong with it. I looked at the space around the signature, at the date, at the notary stamp in the lower right corner, at the name printed beneath the stamp. Then I called Coleman. How long did you know this was coming? I asked. Since the anonymous text, he said. The message described a document specialist. I retained a forensic examiner the same night. I wanted to be ready before they filed. A brief pause. They filed 18 hours later than I expected, which tells me the production took longer than Marcus anticipated. You have the forensic analysis already. I received it 40 minutes ago. I heard papers moving. 3 findings. First, the signature does not match Ethan Brooks's known signature samples across 17 reference documents. The pressure pattern, letter slant, and baseline deviation are inconsistent at a statistically significant level. Second, the notary license number stamped on page 4 belongs to a notary who allowed her Illinois license to lapse 14 months ago, 3 months before the document's claimed date. She could not legally have notarized anything on the date stated. Third, the PDF metadata shows a document creation date of 4 days ago. The file was created on a Windows machine at 11:23 in the evening. Coleman paused. That is approximately 30 minutes after Marcus placed the phone call described in the anonymous text. I set the phone down for a moment and looked at the signature on my screen. My name on a lie. Filed in a federal proceeding, in front of a judge who had been presiding over this case for 2 weeks. I picked the phone back up. What do we do with this? I asked. Coleman arrived at the Riverside Inn at 7:30. He sat at the desk, opened his briefcase with the same methodical calm he brought to every action, and said, I want to explain a choice to you, and I want you to think about it carefully before you respond. I sat on the edge of the bed and listened. We have 3 options, he said. 1. We file an emergency motion tonight to strike Exhibit C, present the forensic findings to the court, and request sanctions and a federal referral. This is the fastest path, and it is legally sound. And the other 2? Option 2. We do nothing until the hearing tomorrow. We allow Hartley to present Exhibit C to Judge Morris. We allow Marcus to take the stand and testify, under oath, that he was personally present when you signed that document. We allow the document to be moved into evidence with their full endorsement. And then we present our forensic findings. I understood immediately. They commit to the lie in open court, under oath, Coleman said. At which point the document is not just a forgery submitted by an attorney. It is a forgery that has been authenticated by sworn testimony. The charges change entirely. Fraud upon the court. Perjury under 18 U.S.C. 1621. Obstruction of justice. Potentially conspiracy if Diana's involvement can be established. He paused. And it becomes significantly harder for anyone to walk it back once they have looked a federal judge in the eye and confirmed it. What is option 3? Option 3 is a version of option 2 with one addition, Coleman said. We inform the court tonight, through a sealed communication to the clerk, that we are aware of the forgery and intend to address it in open proceedings tomorrow. This protects us from any suggestion that we sat on evidence. The court is informed. The trap is set on the record. Do that, I said. Option 3. Coleman nodded as though he had expected that answer. He left at 10:15. I stood at the window for a while and thought about what it meant that Marcus Hayes was going to walk into a federal courtroom tomorrow morning and swear under oath that he had watched me sign a document that did not exist 18 months ago. I thought about what it meant that Diana had allowed this, or had not stopped it, or had not known, though at this point the distinction was becoming harder to hold. I thought about my father's note in the third notebook. The people who stand near something like this will eventually want to say they built it. Don't be surprised when it happens. Be ready. This was what ready looked like. Not aggression, not outrage, not the kind of righteous fury that makes satisfying viewing but loses cases. Ready looked like a sealed communication to a federal clerk at 10:15 on a Saturday night, and a forensic examiner's report in 3 parts, and a 63-year-old attorney driving home through an empty city to sleep 4 hours before the most important morning of his career. Ready looked like patience held long enough to become structure. I picked up the father's envelope from the nightstand at 11:47. I turned it over once. I ran my thumb along the sealed edge. The paper had the particular density of something that had been prepared with care, heavier stock than necessary, sealed with intention. The handwriting on the front had not faded at all. For Ethan. Not yet. I put it in the inside pocket of my suit jacket, which was hanging on the back of the door. Not to open, to carry. Whatever my father had written, he had written it for a moment of wait. And tomorrow was going to be the heaviest morning of my life. It seemed right that he should be in the room. I turned off the light at midnight. At 7:45 the following morning, I walked into the Cook County Courthouse for the last time. The courthouse smelled the same as it had 11 days ago. Cleaning solution and old wood, and the particular stillness of a building that processes human suffering with institutional regularity and has long since stopped being surprised by any of it. I walked through security at 7:58, found the men's room on the second floor, stood at the sink, and looked at my reflection for 30 seconds, then went to find Coleman. He was already outside courtroom 4C. Standing against the wall with his briefcase at his feet, drinking coffee from a paper cup, looking like a man waiting for a bus he had ridden many times before. He did not say good morning. He said, "The clerk confirmed receipt of our sealed communication at 11:42 last night. Judge Morris has been informed." He paused. "He will allow the proceedings to run their natural course this morning. He will not intervene until we move to introduce our counter-exhibits." "He knows what's coming," I said. "He knows something is coming," Coleman said. "That is enough." I put my hand in my jacket pocket for a moment, felt the edge of the envelope through the lining. Then I followed Coleman through the door. Courtroom 4C was fuller than it had been at any previous session. I did not know most of the people in the gallery. Some were press. I recognized the particular quality of attention that comes with a notebook on the knee. Some were Vertex Tech employees, I suspected. There were 2 people I did not recognize, seated near the back, who had the contained, watchful manner of federal observers. I noted them and looked away. Diana was already at her table. Marcus sat in the front row of the gallery, directly behind her, in a dark blue suit, his hands folded in his lap. His posture, the posture of a man who had decided to perform confidence, regardless of what he was feeling underneath it. He looked at me when I sat down. I did not look back. Judge Morris entered at 9:02. The room stood and sat. He opened the session without ceremony, reviewed the procedural status in 4 sentences, and invited Hartley to proceed with the respondent's evidentiary presentation. Hartley rose. He was smooth in the way that expensive preparation makes people smooth. He walked the court through the argument they had been building for weeks. Vertex Tech as a co-developed enterprise. Axiom as a product of collaborative corporate effort. The IP transfer as the formal documentation of an arrangement that had existed in practice from the beginning. His language was precise and unhurried. Then he said, "Your Honor, at this time the respondent would like to introduce Exhibit C, a signed and notarized IP transfer agreement executed between Ethan Brooks and Vertex Tech LLC, dated 18 months prior to these proceedings." He placed it before the court. I watched Judge Morris receive it without expression. I watched Hartley turn to the gallery. The respondent calls Marcus Hayes. Marcus walked to the stand with the ease of a man who had rehearsed the walk. He was sworn in. He confirmed his name, his role, his tenure at Vertex Tech. He answered Hartley's foundational questions with the steady rhythm of someone who had run the answers through his head enough times that they no longer felt like answers. They felt like memory. Then Hartley said, "Mr. Hayes, directing your attention to Exhibit C, were you present when this document was executed?" Marcus looked at the document. "Yes," he said. "I was." "And you witnessed Ethan Brooks sign this agreement?" "I did." "Can you describe the circumstances?" Marcus described them. A conference room at Vertex Tech's offices, a Tuesday afternoon. The date, he gave the date. The time, early evening, after business hours. Ethan reviewing the document, asking one question about the licensing clause, and then signing on page 4. He was specific. The details he invented had the texture of real memory, which is what made it, in some ways, the most disturbing thing I had witnessed in 11 days of disturbing things. Hartley thanked him and sat down. The room adjusted. That is the only way I can describe it. The particular settling of a space when one phase of something has ended and the next has not yet begun. People shifted in their seats. Someone in the gallery coughed. Diana's hands moved briefly on the table in front of her, and then went still. Coleman stood. He did not move toward the podium immediately. He stood at our table for just a moment, long enough for the room to feel the pause. And then he walked forward with the unhurried certainty of a man who knew exactly how much time he had and had no intention of wasting a second of it. "Mr. Hayes," he said, "I'd like to ask you some questions about the financial history of Axiom's development. Specifically, about who paid for it." Hartley was on his feet. "Objection, Your Honor. Relevance." Judge Morris looked at Coleman. "The financial provenance of the asset directly determines the validity of any transfer agreement pertaining to it," Coleman said. "I will connect it momentarily." "Overruled," the judge said. "Continue." Coleman turned back to Marcus. "Mr. Hayes," he said, "I'm going to ask the clerk to distribute copies of several documents to the court. Your Honor, these are respondents' counter-exhibits D through F." The clerk moved. The documents landed on Hartley's table, on Diana's table, in front of Judge Morris, and in the hands of the federal observers in the back row. Marcus watched the clerk approach him with his copy. He took it. He looked at the top page, and I watched, from 3 feet away, as the color left his face, with the quiet, total efficiency of a light being switched off. Coleman looked at the document in his hand the way a surgeon looks at a scalpel before the first incision. Not with drama, but with the quiet acknowledgement that what happens next will be precise and it will be permanent. "Mr. Hayes," he said, "Exhibit D is a set of bank records subpoenaed from First Midwest Bank and Citizens Financial, covering the 24-month period of Axiom's primary development. I'd like to walk through them with you." Marcus was still looking at the top page of his copy. His hands had not moved since the clerk placed the documents in front of him. "Would you describe yourself as having personally funded the development of Axiom?" Coleman asked. A pause. I joined the company after the initial development phase. That is not what I asked. Did you, Marcus Hayes, personally fund any part of Axiom's development? No. Did Vertex Tech LLC fund any part of Axiom's development during the 24-month period reflected in these records? Another pause. Hartley rose. Objection. The witness. The records speak for themselves, Your Honor, Coleman said, turning briefly to the judge. I am asking the witness to confirm what is on the page. Overruled, Judge Morris said. Marcus looked at Hartley, then back at Coleman. Vertex Tech was incorporated after the initial phase. After the initial phase, Coleman repeated. So your answer is no. Vertex Tech funded $0 of Axiom's primary development. That is correct. And Diana Brooks Hayes, did she personally fund any portion of Axiom's development during this period? The room was very quiet. I don't have direct knowledge of her personal. The records do. Coleman walked to the clerk. Your Honor, I'd ask the court's attention to page 7 of Exhibit D. Column marked Total Deposits. Development Account, LLC 7741, Brooks Technology Holdings. The number at the bottom of that column is $847,247.38. He paused. The depositor on every single transaction in that column is Ethan Raymond Brooks, personal funds. The column immediately to the right, third-party contributions, reads 0. Not a reduced amount, not an amount pending reconciliation. 0. He let the number live in the room for a moment. $0, he said again, with no additional emphasis, because none was needed. I was watching Diana. She had been still since the documents landed. Not the performing stillness of earlier sessions, but the absolute stillness of someone whose mind has moved so far ahead of the moment that the body has simply stopped. She was staring at page 7. Her pen was on the table beside her hand, and her hand had not moved toward it. She did not look at Marcus. Not yet. Mr. Hayes, Coleman said, pivoting without pause. I'd like to direct your attention to Exhibit E. This is a forensic examination of Exhibit C, the IP transfer agreement you testified to witnessing earlier this morning. Hartley rose again. Judge Morris raised one hand without looking up from his own copy. Hartley sat down. The examination was conducted by Dr. Sandra Ellison of the Illinois Forensic Document Laboratory,
Coleman said.
Her findings are in 3 parts. I will read them for the record.
He looked at the page.
Finding 1. The signature attributed to Ethan Raymond Brooks on page 4 of Exhibit C does not match the known signature samples of Ethan Raymond Brooks across 17 reference documents. The pressure pattern, letter slant, and baseline deviation are inconsistent at a level exceeding statistical significance. No sound from the gallery. Not a cough. Not a shift. Finding 2. The notary license number stamped on Exhibit C, Illinois Notary Commission number 74792-B, belongs to a notary whose license lapsed 14 months prior to the document's claimed execution date. The notarization on Exhibit C was therefore legally impossible on the date stated. I looked at Marcus's hands. They were flat on the table now, both of them, pressing down as though the table might move. Finding 3. Coleman turned the page. The PDF file submitted as Exhibit C carries embedded document metadata showing a creation timestamp of 4 days ago, specifically 11:23 in the evening. The file was generated on a Windows operating system, not signed or notarized paper, and backdated through manual date entry in the document header. He placed the report on the clerk's desk and turned back to the stand. Mr. Hayes, he said, earlier this morning you testified, under oath, that you personally witnessed Ethan Brooks sign this document 18 months ago, in a conference room at Vertex Tech's offices, on a Tuesday evening. A pause measured in heartbeats. I'm going to give you the opportunity to correct that testimony now. Marcus looked at Hartley. Hartley was looking at the table. The silence lasted 7 seconds. I counted them. Marcus started. Stopped. Coleman waited. I may have been mistaken, Marcus said. About certain details. Certain details, Coleman repeated. He did not smile. He did not press. He simply let those 3 words stand in the middle of the courtroom, where everyone in the room could examine them. Thank you, Mr. Hayes. He turned to the judge. Your Honor, in light of Exhibit E's findings and the witness's revised testimony, the petitioner respectfully requests that the court note the apparent inconsistencies in Exhibit C's provenance for the record, and consider the evidentiary and potential criminal implications accordingly. Judge Morris removed his glasses. He set them on the bench. He looked at Marcus Hayes on the stand for a long, measured moment. The look of a man who has spent 2 decades presiding over the full range of human dishonesty and has learned to recognize its face precisely. This court will take a 15-minute recess, he said. His voice was entirely level. When we reconvene, I expect both counsel to be prepared for closing arguments. Another pause. And I will note for the record that I have referred certain matters disclosed in today's proceedings to the United States Attorney's Office for the Northern District of Illinois. The gavel came down. The room moved. People stood, turned, spoke in low voices. Someone in the gallery near the door said something sharp and quick. Hartley was leaning over Diana's table, his hand on her shoulder, speaking rapidly. Diana was not looking at him. She was looking at Marcus, and the look on her face, contained, cold, devastated, told me everything I had not been certain of until that moment. She had not known about the metadata. She had let the forgery happen, but she had not known how badly it had been done. I stood and put my hand into my jacket pocket. The envelope was there. Heavy stock, sealed edge. 4 words on the front in my father's handwriting. I looked at it for the first time in 11 days, not as a comfort and not as a map, but as the thing it had always been, a gift, timed perfectly, by a man who had understood, before any of us, exactly how this story was going to end. Now, I thought, now is when. The hallway outside courtroom 4C was nearly empty during the recess. Most of the gallery had moved toward the end of the corridor. Voices low, phones out, the particular energy of people who have just witnessed something they need to describe to someone who was not there. Hartley had disappeared into a conference room with Diana. 2 of Coleman's paralegals were reviewing documents at a bench near the stairwell. Coleman had looked at me when we came through the door and said simply, "Take whatever time you need. We have 14 minutes." He walked to the paralegals. I walked the other direction. There was a window at the end of the hall. Tall, south-facing, looking out over the civic plaza below, where a few pigeons were navigating the cold stone in the unhurried way pigeons navigate everything. I stood at it and reached into my jacket pocket. The envelope was there, exactly where it had been since the night I put it there. I took it out. The paper was warm from being against my chest all morning. I turned it over once. The seal had held perfectly. My father's handwriting on the front, for Ethan, not yet, looked exactly as it had in Evanston, in that oak desk drawer 3 weeks ago, when my mother handed it to me without quite meeting my eyes. I broke the seal with my thumb. Inside, 2 folded pages, the same heavy paper stock as the envelope. His handwriting. Careful, architectural, every letter formed with the deliberateness of a man who chose his words the way he chose his measurements. I read it standing at the window with the pigeons below and the city beyond, and 14 minutes on the clock. Ethan. You're in a courtroom. I don't know which one or exactly when, but I know you're there. Because I watched what was forming around what you built, and I knew eventually the structure would be tested. That is the nature of structures. It is also the nature of people. Here is what I want you to know before it is over. You designed Axiom the way I taught you to design anything. invisible, load-bearing, essential. The kind of work that no one sees until it stops functioning. That is not a coincidence. That is what you are. I have watched you your entire life build the underneath of things while other people stood on top of them. And I have never once seen you require acknowledgement for it. I consider that the finest quality a person can have. I consider it yours completely. The people who wanted credit for what you built, I saw them too. I said nothing directly because I loved them and because I believed, as engineers must believe, that a structure only reveals its failures under load. You cannot know what something is made of until weight is placed on it. I needed to let the weight arrive. I am sorry for that. It was the most painful decision I made in your regard. Now you know what they were made of. Win this case. You have earned the right to win it and the judgment to do it correctly. Do not be cruel about it. You will not be. That is not what you are. But I say it anyway because fathers say things their sons already know. Then, when this is finished, and you have had time to breathe, I am asking you to do something I was never quite able to do in my own family. Choose repair over distance. Not today, not this year perhaps, but eventually. The strongest structures I have ever worked on were not the ones that never cracked. They were the ones that cracked, were repaired correctly, and held more weight afterward than before. Your sister loves you. She has always loved you, more than she has been able to say, without also being afraid of you. That fear made her do things she will spend a long time regrowing from. That is her work to do, not yours. But when she has done it, leave the door open. The foundation is yours, son. It always was. I built the first layer of it before you were born, and you built the rest yourself without knowing I was watching. I am proud of you in ways I was never adequately fluent in saying out loud. I am saying it now, in writing, so it cannot be misremembered. I love you. Dad. P.S. The Lord builds things that last, through people who are willing to build quietly and wait. You have been that person your entire life. Do not stop now. The waiting is almost over. I stood at the window for a while after I finished reading. I do not have a precise account of how long. Long enough that one of the pigeons on the plaza below completed a full circuit of the fountain and came back to where it started. Long enough for the city beyond the glass to continue doing what cities do. Moving, indifferent, enormous, entirely unaware. My father had written these pages 2 years before he died. He had sat at that oak desk in Evanston, the one with the sticky second drawer and the brass lamp, and he had chosen every word with the care of a man who would not have the opportunity to revise them. And he had sealed them and given them to a lawyer and said, "My son will know when." He had been right. He had been right about almost everything, as it turned out, which I supposed should not have surprised me, given that he had spent 31 years building things that did not fail. I folded the pages carefully along their original creases. I put them back in the envelope. I put the envelope back in my jacket pocket, not against my chest this time, but in the outer pocket, where I could reach it easily. And I stood at the window for one more moment, looking at the city. Then I turned and walked back toward Coleman. He looked up when I approached and read something in my face that made him nod once, without speaking, the way people nod when they understand something has been settled that needed to be settled. "Ready?" he said. "Yes," I said. We went back in. Coleman's closing argument lasted 11 minutes. It did not need to be longer. He walked the court through the evidence in sequence. The LLC records, predating Vertex Tech's incorporation. The 4 development notebooks. Harold Chen's declaration. The bank records showing $847,000 of personal investment against 0 corporate contribution. The forensic findings on Exhibit C. He did not dramatize. He did not editorialize. He presented the record the way a structural engineer presents a load analysis, with the confidence of someone who knows the numbers are correct and does not require the audience to believe anything beyond the numbers themselves. Hartley's closing was 7 minutes. It was the closing argument of a man who has run out of architecture and is working with whatever materials remain. He challenged the forensic methodology. He raised questions about the LLC filing interpretation. He suggested the bank records reflected only one dimension of a complex financial relationship. He was thorough. He was professional. He was asking the court to doubt things that could not reasonably be doubted. And the room understood that. Judge Morris recessed for deliberation at 12:47. Coleman and I sat at our table while the room thinned around us. The federal observers had moved. The press contingent had reassembled near the door. Diana and Hartley had gone to the corridor. The clock on the wall moved. I put my hand in my jacket pocket, felt the envelope, left it there. My father had spent his career building things in which other people placed their lives without knowing his name. Load-bearing frameworks buried in the walls of buildings that thousands of people walked through every day, completely unaware that what was holding them up had been designed by a man in Chicago who charged a fair rate and went home at a reasonable hour and coached Little League on Saturdays. He had built quietly. He had built correctly. He had built things that lasted. The door at the front of the courtroom opened. Judge Morris returned at 2:19. He sat. He adjusted his papers. He looked at both tables with the measured attention of a man who has made his decision and is about to deliver it to people whose lives it will alter permanently. Then he opened his mouth. Judge Morris did not clear his throat. He did not shuffle his papers or pause for effect. He simply began speaking in the same level voice he had used throughout 11 days of proceedings, as though what he was about to say was a natural extension of everything that had preceded it. Which, of course, it was. This court has reviewed all submitted evidence in the matter of Brooks versus Brooks-Hayes regarding the intellectual property designation of the Axiom Financial Modeling System and its associated source code, algorithms, and licensing architecture. The room was completely still. On the central question of ownership, the evidence establishes, clearly and without reasonable contradiction, that Axiom was conceived, designed, and developed entirely through the personal effort and personal financial resources of Ethan Raymond Brooks, operating through his sole member LLC, Brooks Technology Holdings, during a 24-month period predating the incorporation of Vertex Tech LLC by 11 months. The respondents' claims of joint development and corporate authorship are unsupported by any financial, documentary, or testimonial evidence that has survived scrutiny in these proceedings. He paused briefly, not for effect, but to turn a page. The work-for-hire doctrine, as advanced by the respondent, requires a showing that the work was produced by an employee within the scope of employment, or pursuant to a written agreement designating the work as work-for-hire. Neither condition is met. The petitioner was not an employee of Vertex Tech at the time of Axiom's development. No such agreement exists, and no credible evidence has been presented to suggest one was ever executed. Another page. The court therefore finds in favor of the petitioner. Intellectual property ownership of the Axiom system in its entirety is confirmed as belonging to Ethan Raymond Brooks and Brooks Technology Holdings LLC. Any claims by Vertex Tech LLC or Diana Brooks-Hayes to said intellectual property are hereby denied. I heard the sound of a pen hitting the floor somewhere in the gallery. I did not turn around to see whose it was. Judge Morris continued. Regarding Exhibit C, submitted by the respondent as a purported IP transfer agreement, the court finds this document to be of fraudulent origin, based on the forensic examination entered into evidence as Exhibit E. The document is struck from the record in its entirety. The court has, as noted earlier today, referred all matters pertaining to the creation, submission, and testimonial authentication of Exhibit C to the United States Attorney's Office for the Northern District of Illinois. That referral stands and will include the court's own findings for the purpose of any subsequent federal proceeding. He looked up from his papers for the first time since beginning. The court further notes that the submission of a fraudulent document into federal proceedings and the subsequent perjured testimony offered in support of that document represent a serious violation of the integrity of these proceedings. The court will be filing a formal complaint with the Illinois Attorney Registration and Disciplinary Commission regarding the conduct of Respondent's counsel. Hartley did not move on the matter of damages. Vertex Tech LLC utilized the Axiom system without valid licensing authorization for a period of 11 days following the petitioner's lawful suspension of the license, under Section 7.4 of the governing LLC agreement. The respondent is liable for unauthorized use damages to be calculated at the standard commercial licensing rate established in the petitioner's current letter of intent with Nexus Capital Partners. The court will receive a damages calculation from petitioner's counsel within 30 days. A final pause. The petitioner's request for confirmation of the licensing agreement with Nexus Capital Partners is approved. All legal impediments to that transaction arising from the respondent's claims are hereby removed. The court will issue a formal order to that effect within 48 hours. He closed the folder. This matter is concluded. Court is adjourned. The gavel came down once. The room moved. I sat still for approximately 4 seconds while it moved around me. Voices rising, chairs scraping, the particular dense sound of a space that has been holding collective tension, releasing it all at once. Coleman placed his hand briefly on my shoulder. Not a congratulation. Something more precise than that. An acknowledgement. The gesture of a man who understood that what had just happened was not a victory to be celebrated loudly, but a correction to be received with appropriate gravity. "Well done," he said quietly. "Both of us." I nodded. Across the aisle, Hartley was speaking rapidly to Diana, his head bent close, his hand gesturing in the economical way of lawyers managing catastrophic outcomes. Diana was sitting with both hands flat on the table in front of her. She was not looking at Hartley. She was looking at the middle distance, the specific unfocused gaze of someone whose mind is in a place their body has not yet caught up with. I watched her for a moment. She did not look like the enemy. She looked like my sister. I stood. At that same moment, the 2 federal observers from the back row were moving with unhurried purpose toward the front of the gallery, where Marcus Hayes had remained seated since the recess, very still, in his dark blue suit. One of them spoke quietly to him. Marcus looked up at the man, and then at the door, and then at Diana. Diana did not look back. Marcus stood. He did not resist. That was the only thing, in the end, that surprised me about him. That when the moment arrived, all the confidence drained out of him so completely that what remained was simply a man in a suit standing up from a chair, understanding that he had reached the end of something, and going where he was taken without a word. I reached into my jacket pocket. The envelope was still there. My father's letter, already read, folded back along its original creases, warm from the morning. I did not take it out. I simply let my fingers rest on it for a moment. The way you rest your hand on a wall to confirm it is solid. And then I picked up my briefcase and I followed Coleman toward the door. The $95 million licensing agreement was waiting. Axiom was mine. And somewhere in the hallway ahead of me, my sister was going to have to decide what she was now. The hallway outside courtroom 4C had the quality of a place that does not yet know what it is. 30 seconds after the gavel came down, it was neither inside the proceedings nor outside them. It was the transitional space where a legal outcome becomes a human reality, and where the people most affected by it have to stand while that transition completes itself around them. Marcus was already there when I came through the door. The 2 federal observers had moved him to a section of wall near the stairwell, away from the main foot traffic. One of them was speaking quietly to him, the formal, measured cadence of someone reading from a specific script, which is what it was. Marcus was standing with his hands held slightly away from his body, which is what you do when you understand that the next physical step is not yours to initiate. I looked at him once. He did not look at me. I did not need him to. Victor was 20 feet further down the hallway, already moving toward the elevator bank. He was carrying his jacket rather than wearing it, which meant he had come through the courtroom door moving fast and had not stopped. He glanced sideways as I came out, a brief, reflexive look, the look of a man checking his peripheral vision. And then he did not look again. He pressed the elevator button. I watched him go, and felt nothing about it except a faint, distant recognition. This was what Victor had always been. A man who positioned himself near things that were ascending, and who knew, with impressive speed, when something had stopped ascending. The elevator opened. He stepped in. The doors closed. That was the last I saw of Victor Langley. Diana came through the courtroom door 4 minutes after I did. She stopped just outside it, in the hallway, and the first thing she saw was Marcus against the wall with the federal agents. I was watching her face when she saw it. I saw the precise moment she understood what she was looking at. Not just what was happening, but what it meant for the story she had been telling herself about how all of this had unfolded. Something in her face gave way, not dramatically, not with tears or sound. The way a load-bearing element gives way when the stress finally exceeds the design tolerance. Not an explosion, but a settling. A quiet, total rearrangement of what had been held in place by effort alone. Hartley was beside her, still talking. She was not listening to him. She was looking at Marcus, and then she was looking at me, and then she was walking toward me through the hallway with the particular movement of someone who has discarded all the versions of this conversation they had rehearsed and is arriving at it empty-handed. We stood 3 feet apart in the hallway of the Cook County Courthouse on a Monday afternoon in November, and for a moment, neither of us said anything. "Did you know?" she said finally. "About Marcus, about the account, before the trial." "Not all of it," I said. "Not until the forensic report." She nodded slowly. "I didn't know. About Indianapolis." A pause. "About any of it." "I know you didn't." The sounds of the hallway continued around us. Footsteps, a distant phone ringing, the elevator chiming at the far end. The ordinary machinery of a building that would run through all of this and come out the other side unchanged. "I'm sorry, Ethan," she said, "for what I did. The lawsuit, the IP claim, for—" She stopped. "For all of it." I looked at my sister. I thought about what I wanted to say and found, at the bottom of the available options, the truest one. "I know," I said. I reached into my jacket pocket. Not for the letter. I kept that. But the knowledge of what it said was there, accessible, immediate. Choose repair over distance. Not today, not soon, but eventually. "Dad left you a letter," I said. "You should read it." Diana's eyes changed. A small shift. The particular alertness of someone who has just been told that a door exists that they had not known about. "I have mine," she said quietly. "I haven't—" "I know," I said again. "Read it when you're ready." She nodded. We stood there for one more moment. Two people who had built something together and broken it, and were standing in the space where the break was. And then I nodded once and turned and walked toward the exit. The cold hit me as soon as I pushed through the exterior door. November in Chicago. The Civic Plaza was mostly empty at this hour. A few people moving with their heads down against the wind, a food cart being wheeled away, the fountains shut off for the season. The sky was the flat, purposeful gray of a city that has decided winter and is not going to discuss it further. I stood on the steps for a moment and let the cold move through me. My phone buzzed. A text from Hartwell. "Congratulations, Mr. Brooks. We are ready to proceed when you are. Nexus looks forward to a long partnership. I read it twice. Then I put the phone in my pocket and walked to my car. I drove to the Riverside Inn. I am not entirely sure why. The case was over. I could have driven anywhere. But I had been in room 11 for 8 days, and the day did not feel complete without returning to it once more. The way you return briefly to a place after a long stay, not because you need to, but because departure requires acknowledgement. Philip was at the desk. He looked up when I came through the door. I placed the key on the counter. He picked it up without a word, checked the number on the tag, and placed it in its slot on the board behind him. "Good stay?" he asked. I considered the question honestly. "Yes," I said. "Actually, yes." He nodded and went back to his paperwork. I walked back out to the parking lot, got in my car, and drove into the city as the last of the November light dissolved into the skyline, and Chicago went on doing what Chicago does. Indifferent, enormous, and entirely unaware that a man who had built something invisible and essential had just gotten it back. I woke up in my own apartment for the first time in 9 days. Not the Riverside Inn. Not room 11, with its parking lot view and its curtains that did not quite meet. My apartment, in the building I had lived in for 4 years, with the windows that face east and let the morning in at an angle that is either beautiful or inconvenient, depending on what time you went to sleep. I lay there for a while, without moving. There were no emails I needed to check immediately. No motions pending. No forensic reports waiting for review. No sealed envelopes. The day ahead had the particular open quality of a calendar that has been cleared by the completion of the thing that was filling it. Not empty in the abandoned sense, but cleared in the purposeful one. A surface prepared for whatever comes next. I made coffee. I sat at the table by the east window. I watched Chicago come awake in the November light. The elevated train moving in the middle distance, the steam from a building vent rising and dispersing. 2 pigeons on the rooftop across the street conducting the same unhurried negotiation over the same 2 feet of ledge that pigeons have apparently been conducting since the building was constructed. I sat with all of it for a long time. I thought about what my father had written. That the Lord builds things that last through people who are willing to build them quietly. I had been that person for longer than I had known. The work in those 4 notebooks, the 2 years in the apartment in Wicker Park, the $128,000 wired to my sister without telling my mother, the choice to stay in the engineering when the business side was more visible. All of it had been quiet, load-bearing work. The kind no one sees. There is a kind of faith required in that work. Not just faith in the legal system, or the evidence, or the 63-year-old attorney who carries your case with the patience of someone who has never once confused speed with thoroughness. I mean faith that the truth is, as my father believed, God's preferred construction material. It does not rot. It does not warp. It holds weight across decades, and it does not require maintenance or applause. You build with it correctly. You document it precisely, and then you trust it to stand. I had trusted it to stand. It had. On the morning after, sitting with coffee in a room with no pending motions and no sealed envelopes, I felt the particular peace that I believe God gives specifically to people who have chosen to do the hard, invisible work and trusted that it would eventually be seen. Not immediately. Not on anyone else's schedule, but eventually, which, as my father understood, is the only timeline that has ever mattered for the things worth building. I thought about Diana, not with anger. I want to be clear about that, because anger is the easier emotion and I had earned the right to it. But I had also been carrying it for long enough to understand that it was a tenant and not a landlord. That it had occupied space in me without contributing to what I was building. Diana was going to have a very difficult year. Possibly several. The federal investigation would run its course. The civil proceedings around the misappropriated funds would follow. The company she had run was now functionally valueless without Axiom, and the man she had trusted to manage its operations had used her as a vehicle for his own theft. She would need to account for what she had done and had not done, in legal rooms, and eventually in the harder room that has no judge except yourself. My father had left her a letter. She had not opened it yet. I hoped she would soon. I hoped when she did, it would do for her what it had done for me. Not fix anything, not reverse anything, but give her something solid to stand on while she figured out who she was going to be on the other side of all of this. That was the most I could offer her right now. It was, I thought, enough. The Nexus Capital paperwork arrived by messenger at 10:15. $95 million, structured over a 7-year licensing term with renewal options. I signed it at my kitchen table, using the same pen I had used to fill the 4th development notebook 6 years ago, which I realize sounds contrived, but is simply true. I called Coleman at 11. Done, I said. Good, he said. He paused. Your father would have appreciated the efficiency. I thought about that and found it was exactly right. I want to speak directly to you now. Whoever you are, wherever you are listening to this. If you have ever built something and watched someone else stand in front of it and tell the world they made it, I want you to know that I understand what that costs. Not just financially, not just legally, in the particular interior place where your sense of yourself lives. The place where the distance between who you know you are and who the room currently believes you to be creates a pressure that most people cannot describe and almost everyone has felt. You can survive that pressure, not by being louder than the people claiming your work, not by burning everything down in the name of justice, but by doing what my father taught me without ever sitting me down and delivering a lesson. Build it so well that the truth of it cannot be permanently obscured. Document everything. Date everything. Trust the foundation you laid when nobody was watching. Because what you build with your own hands, in the dark, with your own resources, on your own time, that belongs to you. It has always belonged to you. The people who tried to stand on it without your permission were only ever borrowing, and borrowed things must eventually be returned. Your name belongs on your work. Do not let anyone tell you otherwise. If this story stayed with you, if something in it reminded you of a fight you have been through, a thing you built that someone tried to take, a father whose voice you still hear when the weight gets heavy, I would like to know. Leave a comment below and tell me what part landed for you. Every story I tell for the people who need to hear it. And I only know if I found you when you tell me I did. If you are new here, subscribe. There are more of these coming. Stories about real stakes, real people, real fights worth having. And if someone in your life is going through something like what Ethan went through, share this with them. Sometimes the most useful thing you can do for a person who is fighting alone is let them know that someone else fought the same fight and found their way through it. Thank you for staying until the end. It matters more than you know.